Welcome to the 59th episode of Call to the Bar, International Law Over Drinks. I'm your host, Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra. Today we are discussing the improbably named President Donald J. Trump's comprehensive plan to end the Gaza conflict, as enacted into actual international law by the UN Security Council. If you hear me gulping, well, there's a lot to swallow here. Joining me to discuss how a real estate developer and reality television star plans to bring peace to the Middle East are two Call to the Bar stalwarts, Associate Professor Tamsin Philipa Paige of Deakin Law School and Associate Professor Ntina Tzouvala of UNSW Sydney. But before we begin, I remind everyone, particularly this evening, that in these informal conversations, we are, as always, speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. And before we get down to business, our traditional first question, everyone, what are your drinks? Tamsin.
So I've read the resolution and the peace plan and some of the transcript of the meeting in which it got enacted, and I felt the need for something that felt like a bit of a warm hug this evening to deal with this. So I have a hot chocolate, which is a Grounded Pleasures Sicilian hot chocolate this evening, and it is living up to the expectations of feeling like a warm hug.
That's a very mature way to cope with this level of, I don't even know what the relevant noun
This
is.
is one of those times where I really wish that I wasn't 10 years sober.
Dina.
Yeah, I am. My feelings are very similar to Tamsin's. It's been a very hot day in Sydney, but I'm nevertheless having a peppermint tea with some honey.
Right,
Even
well,
with recording late, I yesterday someone served me a very strong gin, so tonight I have to be a bit sensible.
that's not normally a calculation I make, but I respect your restraint. So I kicked the evening off with a bent spoke barley griffin pale ale made right here in Canberra,
Nice.
and am now presently drinking a rolling Sauvignon Blanc Semillon blend, or as we tend to put it in Australia, where we abbreviate everything, a Sauvi Semi, produced in Mudgee, New South Wales. And given the way I anticipate the evening going, I have literally brought the bottle. So we'll see how the host goes compared to two sober co-hosts. Right. I'm going to begin unconventionally because it's been so conventional so far. I'm going to take 5 minutes to read extracts of UN Security Council Resolution 2803 and its annex, just so we have a flavour of what we're discussing. The Security Council, welcoming the comprehensive plan to end the Gaza conflict of 29 September 2025 and applauding the states that have signed, accepted or endorsed it, and further welcoming the historic Trump Declaration for Enduring Peace and Prosperity of 13 October 2025, determining that the situation in the Gaza Strip threatens the regional peace and the security of neighbouring states. 1. Endorses the comprehensive plan, acknowledging the parties have accepted it, and calls on all parties to implement it in its entirety, including maintenance of the ceasefire. 2. Welcomes the establishment of the Board of Peace as a transitional administration with international legal personality that will set the framework and coordinate funding for the redevelopment of Gaza pursuant to the comprehensive plan, until such time as the Palestinian Authority, PA, has satisfactorily completed its reform program and can securely and effectively take back control of Gaza. 3. Underscores the importance of the full resumption of humanitarian aid and cooperation with the BOP into the Gaza Strip in a manner consistent with relevant international legal principles and through cooperating organisations, including the United Nations, the International Committee of the Red Cross and the Red Crescent, and ensuring such aid is used solely for peaceful purposes and not diverted by armed groups. Authorises member states working with the BOP and the BOP to establish a temporary international stabilisation force, ISF, in Gaza to deploy under unified command acceptable to the BOP with forces contributed by participating states. Annex 1. President Donald J. Trump's comprehensive plan to end the Gaza conflict. 1. Gaza will be a de-radicalised, terror-free zone that does not pose a threat to its neighbours. 2. Gaza will be redeveloped for the benefit of the people of Gaza who have suffered more than enough. 3. If both sides agree to this proposal, the war will immediately end. Israeli forces will withdraw to the agreed upon line to prepare for a hostage release. 7. Upon acceptance of this agreement, full aid will be immediately sent into the Gaza Strip. 8. Entry of distribution and aid in the Gaza Strip will proceed without interference from the two parties through the United Nations and its agencies and the Red Crescent. 9. Gaza will be governed under the temporary transitional governance of a technocratic, apolitical Palestinian committee with oversight and supervision by a new international transitional body, the Board of Peace, which will be headed and chaired by President Donald J. Trump, with other members and heads of state to be announced, including former Prime Minister Tony Blair. 10. A Trump economic development plan to rebuild and energize Gaza will be created by convening a panel of experts who have helped birth some of the thriving modern miracle cities in the Middle East. Many thoughtful investment proposals and exciting development ideas have been crafted by well-meaning international groups and will be considered to synthesize the security and governance frameworks to attract and facilitate these investments that will create jobs, opportunity, and hope for future Gaza. 11. A special economic zone will be established with preferred tariff and access rates to be negotiated with participating countries. 14. A guarantee will be provided by regional partners to ensure that Hamas and the factions comply with their obligations and that new Gaza poses no threat to its neighbors or its people. 16. Israel will not occupy Gaza. Well, isn't that nice? So my first question is, haven't we had a lot of International Court of Justice rulings on the continued importance of self-determination recently? And how is any of this, I mean, quite apart from the fact that it's not even written in one literary style, right? Like, it's written in standard Security Council jargon, the kind of sucking up prose one needs to deliver to President Trump, and bits from a bad real estate brochure. But quite apart from my concerns with its literary merit, how is it remotely consistent with that fundamental norm of jus cogens self-determination? My second question, because I'm going to overload this at the front, is can the UN Security Council just, pardon the pun, trump jus cogens and legislate against fundamental norms? My third and final question is, am I the only one taking crazy pills? So who can help me here? Dina.
Right. Starting from the most important question about the crazy pills, the answer is no, obviously. If we could have avoided them before this year, now we are back. So look, it is remarkable to me, and I think it speaks to a very particular moment, and I'll get to that a number of states, including permanent Security Council members, UK and France, who just recognized Palestine as a state a month and a half ago, I'm going to say, also voted for this resolution, right? In which basically it says, if the PA does the reforms, the conditions may be in place for a credible pathway to Palestinian self-determination and statehood. Not even the conditions will be in place. We might or might not happen. As a reminder, as you said, Douglas, very well, the ICJ said unequivocally, obviously, that self-determination, at least in this context of foreign occupation, is a jus cogens norm. And it also said in very clear terms that the termination of the occupation needs to come swiftly and unconditionally, exactly because you cannot place conditions on your non-violation, on stop violating jus cogens norms, right? The idea, I think, as you have also said in the past, that for Palestinians, statehood would be some sort of reward for good behavior, which is exactly what the Security Council seemingly now legalized, sits squarely with the doctrinal understanding of self-determination as articulated by the ICJ. But I would also say as articulated by a series of UN General Assembly resolutions starting from the 1960s onwards, right? And we can discuss, of course, if that was ever exactly true. If that was ever exactly true that, there are no strings attached. I think there were strings attached to many forms of self-determination. But what I do think is remarkable, and what I do think forms a real departure from existing international legal practice, is placing these conditions so explicitly. So basically saying that making explicit the linking of statehood and self-determination to particular conditions, I would say that was always in the background, but since the 60s, it had to stay in the background because it had become bad optics. So that is the first question, the sort of like, how does this square with self-determination? I think the short answer is, based on like the view of self-determination that the ICJ has and the UN General Assembly resolutions have articulated since the 60s, it doesn't. It's simply, if it is a vision of self-determination, it is a competing vision of self determination that I would say sits very orthogonally with international law as it's crystallized after the 70s. So that's the one. The second question, which is, can the UN Security Council do it? That's an interesting question, and I think Tamsin might be better for it, better place to answer it. My question would be less, can the UN Security Council do it? And more, what are the consequences or what is the legal effects of when it does do it, which it just did? And I would say that my understanding, I'm not a doctrinal scholar of the Security Council, but my understanding is, we would have to go back and read, obviously, Article 103 of the UN Charter that famously says that obligations from other treaties, right? It doesn't say all international legal obligations are, pun intended, trumped by obligations that stem from the chapter. Obviously, obligations that arise from the UN Security Council activities stem from the charter, excuse me. It doesn't say that UN Security Council resolutions, though trump use cogens norms, right? What can be done about it, I think, is a different conversation. And I think, in a sense, it's almost a little bit missing the point, because I think we could imagine scenarios in which we could get some sort of authoritative pronouncement of that. But the question is, in this particular case, in which basically my understanding is the dilemma that was presented to the Palestinian Authority is, either you kind of acquiesce to this or the bombing will resume. Even if we think that for some reason there is a way for use cogens to trump the resolution, I would say this would feel slightly more, a bit more like of a theoretical intellectual exercise than
Well,
an
I mean,
actual.
theoretical intellectual exercises are what we're here for. And,
Yes.
we know things are bad when we get Tamsin, our, law and literature, queer theory of international law scholar, to do the doctrinal Security Council stuff. But Tamsin, we're about to inflict that on you. But the one
Yes.
side point I want to make here is, not only is the whole kind of, statehood and self-determination being made conditional on acquiescence to this plan, as Tamsin likes to put it, it also risks legalizing things that feel more than a bit war crimey, right?
Yeah.
Because in paragraphs 7 and 8 of the Trump plan effectively say, you'll get food if you agree to this plan, which
Yeah.
feels a little bit like legalizing the war crime of starvation that, at a minimum, has very clearly been going on before we even get to the whole question of genocide. In any event, Tamsin, I am. Oh no, and I'm just going to bracket that outside this recording in the Call to the Bar group chat, we've been debating the heretical proposition of whether Dapo Akande might be wrong as to whether we haven't quite elevated him to sainthood yet, but he may yet get there. We may yet canonize him. But as to whether Security Council resolutions are judicially reviewable for breaches of peremptory norms before the International Court of Justice. But let's park that and just go to Tamsin.
I
Can the
will go.
Security Council do this? And can you walk us through the relevant provisions of the Charter before one or all of us explode in rage?
Okay, so I'm still dealing with the question one. We haven't even got to question two yet. Like that first three questions around crazy pills. We haven't got to the next step of that. And yes, if I am having to do doctrinal analysis, then everyone done fucked up. And to quote Shakespeare, all art punished. Um, because boy howdy. First thing I'd like to say is that my understanding of self-determination from the recent stuff is that it's an obligation erga omnes that the prevention of which is a use cogens violation, rather than self-determination itself being a use cogens norm. But that's I may be wrong there.
No, thank you. I think that's a useful distinction. We might come back to the substance of that later.
Um, However, we actually have a long history of of Security Council, for want of a better term, jurisprudence um, overriding self-determination. And we have a long history of Security Council discussions saying this will override self-determination, but the threat to the mandate of the Security Council in the situation warrants overriding self-determination as one of the core principles of statehood. And it's worth saying is that self-determination within the Security Council context goes beyond just what we think around self-determination of non-self-governing people. Self-determination by Security Council reasoning actually is an ongoing right of states once they're even in existence to freely determine their own form of government without outside interference. And so we actually have lots of instances, and if you want to know what they are, go read my book on the Security Council and threat to the peace, where even China, who is the most reluctant to override self-determination, has said no in this instance. Actually, maintenance of international peace and security matters more than self-determination. So we have history here. And we have history here, but we also have got this history before we had some really clear articulations on the legal status of self-determination. So this is where it gets a bit fuzzy in that regard. But no. This is anyone who's seen the Call to the Bar group chat knows how fucking angry having to read this Security Council resolution made me. Um, so like this is just outrageous, and I'm going to get to the legal reasons later, but yeah, Dapo Akande is absolutely 100% wrong. There is no space for judicial review of the Security Council. This is why I keep saying international law has no capacity to be a rule of law system, because the UN Charter places the Security Council above the law. They have placed the Security Council in a position to make laws through Article 25, where there has been a decision of the Security Council, there is binding law upon all states, but by also providing them with the veto and making sure that there is no judicial review mechanism for Security Council decisions in the Charter, they're above the law.
Tamsin, can you just walk us through that, particularly listeners who aren't familiar with the text? So what's the significance here of Article 25?
Article 25 says that any decision of the Security Council is law for all member states. There is an agreement by becoming a member of the UN. So 195 states now, isn't it? Or something like that. You agree that a decision by the Security Council is legally binding. It's law. So this is why we have the debates of, where Security Council resolutions say the Security Council determines or decides, as opposed to they urge or they encourage. Because as soon as you use the magical decides word or a close facsimile of it,
And here we've got determines pretty
determines. Yeah, yeah.
prominently.
I am. People can debate this all you want, but I'm taking this as a decision because we have a strong history of decisions around Palestine and the Security Council. Palestine as a situation has been considered a threat to the peace on the Security Council jurisprudence since 1948. It was the first ever threat to the peace. It's still an ongoing Article 39 determination. So yeah, this is law. This is straight up just law. And it's horrific because, as we'll get to later, it creates so many other problems beyond this. And this is where I actually went to the fact that China abstained. China has a long history of disagreeing with everything that everyone stands for in the Security Council, but everyone else agrees, so they'll abstain to not stand in the way, but making their objections noted. And their first objection to the resolution is that it's vague and unclear. That's it. They've said, look, this is the exact quote. I quote from the meeting transcript. First, the resolution is vague and unclear on many critical elements. The pen holder requests the Council to authorize the establishment of a Board of Peace and International Stabilization Force, which will play a key role in post-war governance in Gaza. It should have explained in detail their structure, composition, terms of reference, and criteria of participation, among others. End quote. Straight up, they're not happy with the fact that, no one knows what this actually means.
Well, I'd also like to throw into the mix that paragraph 14 suddenly introduces the term of New Gaza. So it has a completely new entity in international law separate from the rest of Palestine just being created.
Yeah, and I haven't looked at the signatories, but I was under the understanding that the 20-point peace plan was signed between Hamas, who everyone denies is a governmental force, and they're a terrorist organization instead, which don't get me started on how legally meaningless terrorist is as a word. And yet now it's saying that there will be no more Hamas and it's binding the Palestinian Authority. Is that the Palestinian Authority in all of Palestine or just the Palestinian Authority in Gaza? And if Israel is not to occupy or annex Gaza, does that mean that they're cool with them annexing the West Bank? I have so many questions before we even get into the fact that this created a giant fucking legal paradox that has made me want to punch every single person involved really hard, possibly with a claw hammer.
Right. Well, it's a situation redolent of violence, so maybe that's an appropriate response. It's going from the epistemic violence to the actual violence. Tamsin, can you summarize for us briefly what Akande's argument is that the ICJ could review such decisions and why it's wrong?
Okay, so Akande has briefly made I haven't read it in detail for a while, but he's made an argument that there is potentially scope where a matter comes before the ICJ that addresses a Security Council resolution, that then the ICJ could rule on the legality of that and therefore render some of it invalid. Dina, do you want to unpack it a bit further?
Yeah, I'm not on top of the Akande argument too much, but basically, that's not an entirely hypothetical. Well, some of it is hypothetical, but obviously the ICJ was just saved from having to deal with that in the Lockerbie case, right? Because an instance in which the ICJ would have to do something like this is obviously not some sort of abstract review of constitutionality.
And Akande does reference the Lockerbie situation in that piece.
So just to explain, basically the argument would be State A is bringing a case against State B, and it's challenging an act or omission of State B, but State B says, I undertook this act or omission because I was under UN there was a UN Security Council either mandating me or allowing me to do so. And as Tamsin said, based on Article 25, and I would say based on Article 25, combined with Article 103 that says obligations under the Charter are of superior legal validity in comparison to other treaties, though. Therefore, you can't do anything, right? And basically, that's what happened halfway in the Lockerbie case, which is Libya brought a case against the UK, but ultimately, what we were dealing with is action that the UK had been authorized to do under the Security Council. It never got exactly decided because basically the matter was resolved, right, outside, and the case became moot. So the argument, as I understand it, is that in such instances, it would be possible for the Security Council to say that because, for example, for the ICJ to say that because said UN Security Council resolution is against use cogens, it is a violation, it's invalid, right? It has no effect, legal effect under international law. To me, the more persuasive argument is not the Dapo Akante argument, to be honest. I think if there is a way out of this conundrum, is much closer to the argument that Zanakopoulos makes in disobeying the Security Council, right? In which he says, of course, all Security Council resolutions that are, let's say, under Chapter 7, they're valid. It doesn't, though, mean that they don't clash with other obligations. And his argument is Article 103 doesn't tell us that they always prevail. It tells us that they prevail when they clash with other treaty obligations. It doesn't say anything about custom. I think that's the less persuasive argument. But
I'm going to quote Rob McLaughlin on custom.
And it doesn't, yeah. I'm not dying on the hill of custom, but I am dying on the hill of use cogens. But Zanakopoulos' argument is that doesn't invalidate the resolutions. It just creates a conflict between two valid norms, because conflicts in some senses can only be between two valid norms. And his argument was that not only theoretically, but his argument is we have instances in which states indirectly said that they were basically going to start disobeying the Security Council resolutions. And the argument was the resolutions that followed Lockerbie, right? That at some point the African Union said, guys, from 1st of January 1997, whatever the year was, we're just not applying sanctions against Libya anymore. We are just not doing it. And his argument was that this is a form of countermeasures. It's a very complicated argument, but it's an argument I think
you've distilled it as well as I've ever heard it put.
I have to say he was my teacher at UCL, so I feel I have been.
Well, he was my colleague and good friend in my first job at UCL.
But from there, on the note of custom, just to give the Rob McLaughlin quote because it's fantastic, is the invocation of custom is the last bastion of the coward, which I particularly like that quote because it's a very Rob one. But there is potentially an argument there for countermeasures, but there is no mechanism for an ICJ review because it creates what ends up happening because the Security Council, to quote Inga Osterdahl, may do whatever it wishes and it will be legal. Amazing quote from her book Threat to the Peace from I think 1997, which inspired my PhD. That there is the problem we have is that what happens is we end up with a legal paradox where you have a conflict which can't be readily resolved because there is no avenue for a judicial review to resolve it. So the question here...
I mean, in sort of a medieval cosmology, it's like having two rules. One that says anything the king says is law, and another rule that says even the king may not breach natural law.
But I would say, like, there is a clash, but the fact that it cannot be resolved through judicial review doesn't mean it cannot be resolved, because the argument would be international law.
Can I finish?
Sure.
the problem you have is that all of the arguments around use cogens and Security Council come down to, well, the Security Council, the clash with the use cogen means that, the Security Council's law is invalid or whatever. And there have been a number of people who have made that argument in different fora. I'm not convinced. Why I'm not convinced is that there is no clear line about, do you excise the use cogens violation from the resolution and the resolution stands it by itself, or does the whole resolution become invalid? And this is where I'm saying we create a legal paradox, because at what point, what gets removed, what stays, and with no mechanism for a judicial review, you actually have no way of resolving that question of the legal paradox of, at what point, what parts are invalid because use cogens can't be their preparatory norms, and you can't legislate them out of existence even if you're the Security Council in principle. But does that mean that the whole resolution is no longer binding under Article 25, or just the bits that are use cogens violations? And that's the paradox. We have these two things, and we don't know what laws prevail over the whole situation as a result of the conflict, because depends on how you deal with it. Is the whole law invalid
Mm,
because you can't engage
right.
in making use
And I
cogens
mean
violations
that's
legal,
yeah.
or do you just remove the use cogens violation a la kind of contract law?
Yeah. So, and again, you're so two threads I'd like to draw out of this, one from Tamsin's comments, one from Dina's. So, Tamsin makes the point that, in a national legal system, we'd have rules about this stuff, right? That, if you have constitutional or administrative review, you have a series of principles about what you do in a case of conflict between a legislative enactment and a fundamental norm. And that might be the whole thing is struck down, or you read it down, you try and come up with the narrowest possible construction under which it's still legal, or you excise the offending bits and leave the rest standing. We don't have those principles in the international system because the UN system was not set up with direct administrative and judicial review. And what we've been talking about on the Akande thesis is essentially collateral review, right? You have two actors who are put in a position where they have a contest about what their legal obligations are, and as it were, you indirectly challenge the validity of the Security Council's position. But in a practical measure, we've all been sort of saying, well, what's the practical import of all of this? And I think there, um, in terms of the interaction between international law and politics, Dina's point about Libya is really quite helpful. You know,
I
the
agree.
so a lot of international law, be it custom, the last resort of the coward, or treaty making or whatever else, is a whole bunch of brave first movers jumping ahead of the pack, planting a flag and going, the law is here. And if you turn around and no one has followed you, you have not succeeded in lawmaking. Or if after a while everyone looks sort of nervous and shuffles back towards the previous line, you've also not succeeded in lawmaking. So there's always a risk when you make that first mover point of trying to expand what international law is or what the powers of the Security Council are, that you go too far.
And
Now, Dina may want to jump in on that point, but I also want to come back to Tamsin on the historical point of why the hell, given all the liberal democracies who set up the UN, did we not have judicial review of the Security Council? And now, to all of us inside the system, that's probably a fairly obvious point, but I think it's one worth teasing. Dina, did you want to come in on anything before I go to Tamsin on that?
Yeah, because I think in a sense it responds partly to the question. My answer would be, and again, that's a very Xanakopoulos type answer, which is we do have rules. It's the rules of countermeasures. And the rules of countermeasures say you make a judgment and you take the risk that this judgment might be wrong, in which case you have just broken the law. But this is like countermeasures is a body of rules in international law, is just looks extraordinarily different from what a constitutional system of
Right,
review looks like. But to me, it's a perfectly counterintuitive but real body of rules that says
right,
if
right.
you think that at the end of the day the Security Council has acted unlawfully, what it did in this argument is not invalid. That's, I think, the difference between the Akande and Giannakopoulos argument, because Akande, in my view, the problem with Akande is tries to emulate a domestic legal system in a system of centralized constitutional review. Whereas Giannakopoulos fundamentally says, no, this remains in many ways a decentralized legal system. We have a body of law that says who makes the call, and it's the body of countermeasures, but it delegates to states power, but it also delegates legal risk, which is if you're wrong about your judgment, you have just opened yourself. And of course, there is the world of politics, right? But I think countermeasures in itself takes us to the world of politics, which is countermeasures are also fundamentally only open to states that have the power and the political willingness to do countermeasures. And for example, the African Union in regards to Lockerbie, some would say was willing to do it. I don't think that currently anyone is willing to do anything about Resolution 2803.
So I'm just going to bracket a quick definition of countermeasures, then go to Tamsin. So for anyone who's not familiar with the idea of countermeasures, essentially the idea is that international law is a non-hierarchical system with the exception of the Security Council, which Tamsin can come back to, but essentially it's a level plane with actors who just interact with each other largely without hierarchy. So, think of indigenous law or customary societies, right? So if someone offends against you, you don't go to central authorities because by and large there aren't any. So what do? You take measures in response to the breach against you. So you are allowed to breach, or you claim you're allowed to breach the law in response to a prior breach against you. And the purpose of that is to get the other party to resume compliance with their obligations. Now, the problem is, if you're wrong in judging them to be in breach by taking a countermeasure, you are the one who is in breach. And so I think actually, this is all unpacked in a previous episode, which I'll put in the show notes, when Tamsin talked about Gabčíkova-Nagamaros, the Danube Dam case, where everyone was like, you're in breach, I can take action against you. And then the other party was like, no, now you're in breach, I can take action against you. And the ICJ was like, children, behave. You're both in breach. No one's in the right. No one got to take countermeasures. So I'm going to leave it at that and throw to Tamsin on Security Council history and why they're above the law.
Okay, so Security Council history and why they're above the law. Before I get to that, I am going to sit here and say that on current articulations that we have of the law, I actually think China's response to this resolution does mean that the Security Council can legally override self-determination even in this situation, which is horrific. Because China's second objection was that this violates the fundamental principle of Palestinians governing Palestine, and they still didn't veto.
I'm pulling a very sad face.
Literally, and I'll quote here, secondly, the resolution does not demonstrate the fundamental principle of Palestinians governing Palestine. Gaza belongs to the Palestinian people, not to anyone else. Any post-war arrangements must respect the will of the Palestinian people and give full play to the vital role of the Palestinian Authority. The resolution outlines post-war governance arrangements for Gaza, but it seems that Palestine is barely visible in it, and Palestinian sovereignty and ownership are not fully reflected. And I'm going to stop quoting there. And yet they still didn't vote.
That sounds surprisingly crit from China.
And they did not veto, which goes back to the long history we have of the Security Council accepting that their mandate for the maintenance of international peace and security overrides even self-determination. So, that aside, Security Council history, and we've kind of dealt with this a little bit, well, a lot, in the previous episode with Aoife O'Donoghue, where we talk about the veto in particular. But Security Council history, we have in the end stages of World War II, the Allied powers coming together and saying, well, the League of Nations fucking didn't work, did it? So what do we do this time? And how do we make sure that we don't have this happen again? We'll create a new body, we'll call it the United Nations, and because we're the awesome Allied powers, we will guarantee peace and security through the use of force and a monopoly on the use of force. And to anyone out there who says, well, it's not a monopoly on the use of force because self-defense under Article 51 exists, please finish reading Article 51 because it says until the Security Council decides to act. So, monopoly on use of force, but how do we make sure this doesn't get abused? Well, we introduce a veto, which means that any of the five major allied powers who are that can veto the use of force if we don't all agree. And we'll also make sure that that can't get amended out of existence by giving ourselves a veto power over amendments to the charter. And reform of the charter has to then be ratified by a certain number of states. I think it's 66%, and all permanent members of the Security Council. So there is a veto of the Security Council permanent members over any amendment to the charter, including amendments to abolish the veto. So, and we also then say, well, we want to make sure the Security Council has teeth and that what we say is law. So Article 25 exists to say a decision of the Security Council is binding law on all member states. So what we have here is this structure that seems really good at the end of World War II of actually we've just fought this massive war, we've worked together to stop the fascism and the this and the that and the genocide, and now we're going to keep guaranteeing peace through strength and our willingness to use force to do that. The problem is that they all fucking hate each other, and as time goes on, self-interest starts to trump the mandate for the maintenance of international peace and security, which is what we kind of keep progressively seeing. You also have the communist revolution in China like 3 years later, and the exile of the Republic of Chinese government to Taiwan, who, and I can be corrected here, as far as I'm aware, still maintain that they're the real Chinese government, broadly. And so until 1971, they held the Security Council seat, not Communist China, until it got to a point where the world said, look, actually, reality needs to prevail over form here. And that seat, the seat for China, needs to go to actual China, not the Republic of China government in exile in Taiwan. And but what we have here is this system that was set up by very well-meaning people to set up the four major powers and France as the permanent members and the guaranteers of international
Take
peace and
that,
security.
France.
I tell no lies here. That's just the way it is. And then but what this means is that as we've had changes, that makeup has changed. The USSR has become Russia. We've done an episode on that and to why that's actually still really legally consistent and valid. Republic of China became People's Republic of China and after a number of years after the Communist Revolution. But mostly what we have is that the people with the power actually said, if you want us to implement this system, we get to keep our power. We don't become subject to the law. And that's the history of why we have it. People with power are very reluctant to give up their power. And when you put that at an empire scale, you get the Security Council.
Well, that's depressing but accurate. I'll just say, in case I forget to put it in the show notes, on countermeasures, Danube Dam was episode 36, and Aoife O'Donoghue spoke to us on Security Council reform. Is it possible? Brackets, no, it's not, in episode 20. So we've mentioned the communist powers, so let's go to a Marxist scholar. I know that's a terrible segue, and Dina can like stab me the next time she sees me. But I just want to step back a bit because, we had the point where China took the kind of critical theory approach and said it's almost as if we're erasing the Palestinians here. So Dina, it seems to me like this resolution positions an entire people, the Palestinians, as sort of violent and irrational and incapable of governing their own affairs, and who very expressly in the Trump plan need to be brought into the system of world capitalism for their own good and to have, free economic zones. So they need to be subjected to, for want of a better term, like if we were just imagining a phrase, it might be something like international governance as a sacred trust of civilization until they can stand on their own 2 feet.
As a
Um,
point of order, they weren't bringing into free economic zones. They're being brought into Trump-controlled tariff economic zones as law under the peace plan that's now Article 25 into law.
I don't generally swear on this podcast, and I'm not going to make an exception now. But in any event, look, Dina, if only someone had written a book on this. Look, if you were hypothetically to have written such a book, what might it say?
Oh God. So look, yes, I mean, obviously I agree with everything you're saying. And in some ways you could make an argument that says, look, there are some things that are very unique about Resolution 2803. But if you put it next to another resolution, Resolution 1483 of 2003, which is the resolution the UN Security Council passed after the US, UK, and allies invasion of Iraq, you will see some important differences, but you will also see some important similarities. And the same applies to resolution. I'm going to say 1444, which was the resolution that established the international peacekeeping force in Kosovo, again after the 1999 NATO intervention. So there is a number of continuities here, which is using UN Security Council resolutions to legitimize and legalize things, and especially economic reforms that otherwise would be unquestionably unlawful under especially the law of occupation, and especially what we call the conservationist principle, that basically says, in a number of variations, but basically says the occupying power is prohibited from changing the laws of the occupied territories unless there is very limited exceptions. And that obviously, if you have good lawyers, the exceptions are less limited than they should, or less limited than they should, etc. And that is
You can also get the same result with very bad lawyers.
well, exactly. Yes, the very good and very bad lawyer can endure the same point. And that is a practice that the UN and the relevant powers applied in Bosnia and Herzegovina, applied in Kosovo, applied in East Timor, and the non-UN powers, but the authorized by Resolution 1483 aligned powers undertook in Iraq, right? Where we saw less perhaps in the modality of a real estate agent and more in the modality of a neoliberal technocrat, but we saw things like mass privatizations. We saw things like firing the whole public service because we had to de-Baathicize Iraq, etc. So in many respects, there is very significant continuities with practice. And indeed, the UN, that doesn't apply to Resolution 1483 about Iraq, but the UN's claim, and I don't know if that has changed, was that the laws of occupation do not apply to them as a matter of law because they're not an occupying power. They are a benign and administrative power, and therefore all these privatizations did not even engage the conservationist principle. That was the position of the UN Council and Legal Council up until 10 years ago. I haven't kept up, so that might have changed. But in the peak of international territorial administration, the UN was claiming we are not an occupying power. That didn't apply to Iraq, right? Because in Iraq, it wasn't US forces, it was the UK and the US. And Resolution 1483 explicitly said that IHL applied in Iraq.
Right.
And I think that takes me to what is discontinuous between Resolution 2803 and these previous resolutions, which is Resolution 2803 does not mention international law. And I think Tamsin is really on the money in the sense that in many ways they are empowered by international law, but they don't consider currently to be in any way subject to it, right? If you read Resolution 1483 about Iraq, and I'm not here to defend anyone who was involved in that, but it talks about IHO and it talks about general international law, and in a number of occasions it says that this is that the occupying power has to respect international law. That doesn't mean that that's what happened, but I feel there is a real discontinuity here in not even making these symbolic gestures towards international legality, right? We might be empowered under the charter, but once we get empowered, we don't even pretend that what we authorize follows the basics of IHL or general international law. And to me, hypocrisy is annoying, but hypocrisy allows you to call out the hypocrite. Whereas once you give up with the hypocrisy and you're like, no, we are gangsters, you can't tell the gangsters that they are gangsters because they just accepted it.
So that was an amazing tour de force, and I agree with approximately 98.75% of it. I'm just going to add a couple of teeny fact checks, one of which is there are two passing references to international law in paragraph 7
Oh, I apologize.
of no, but it only the fleeting glance kind of reinforces your point, right? In 2803, paragraph 7 says that the International Stabilization Force
Yes.
must act consistent with international law, including international humanitarian law.
Yeah, fair enough. But not the Board of Peace or whatever it's
No,
called.
no, 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 no.
And
That is
these are
also
the
linked
people
No,
with
who
they,
will
they,
sell off the assets.
the new
the other.
colonial board that has been mandated under law now to attract investors.
Yeah, the East India Company,
Yeah.
chaired by, of all people in the Middle East, Tony
Oh,
Blair.
a
and
beloved
and Donald
citizen.
Trump,
Yeah,
who
but I'm still like I'm still back with an earlier episode that Dina chaired, where the analysis was just Board of Peace, Tony Blair, Middle East. Like, why is no one using the word colonialism? Right,
yeah, like this is
and the
straight
last
up
time the
a
British administered Palestine, that went so well.
yeah, we're literally back at that shit. This damn fool
Another
colonial nonsense.
Yes, colonial nonsense indeed. But the other tiny one, just for complete accuracy, was Dina did incredibly well to try and recall the relevant Kosovo UNSCR from memory, but it's 1244, not 1444. But also my considered view on the whole idea that the UN can't be an occupying power and is not subjected to humanitarian law unless it is expressly bound by a Security Council resolution is, with all due deference to my previous comments about not swearing on the podcast often, well, fuck me.
Yeah.
I'm actually fairly certain that that's still the position. They have also previously made arguments, and I don't know how these
For
have
the
panned out.
benefits of a visual medium, I'm refilling my glass.
Yeah, they have also made arguments previously that UN peacekeepers have immunity from sexual violence claims against them committed while engaging in peacekeeping because of the international organization
Well, that's a
immunities.
sufficiently important and depressing topic that we might
And so
hold
it's
for
so it's
season
a case
three.
of that situation may have changed, but I'm not as far as I'm aware.
Okay, look, we could go on about this forever, and we're already over 50 minutes. So I'm just going to say, in terms of like very considered, constrained reflection, OMG, that's been a lot. So I'm going to bring us back to a closing question, and I'm actually, because everyone here's talked about their favorite underrated characters in fiction, I'm going to go back all the way to season 1, and particularly in this context, ask about escape routes. Dina, Tamsin, at this moment in history, what are you reading, viewing, or listening to at present as an escape route from international law? Dina.
Okay. So to you both and to our listeners, please don't judge me.
I can't promise that.
Fair enough.
Actually, no, I can. Friends don't judge each other; they judge
Eh,
other people together.
exactly. So I am a big fan of Korean TV, but not even like comedies or whatever. I love a Korean reality show. And in the past couple of weeks, I've been an avid watcher of something called Physical Asia, which is a sequel of Physical 100, in which a number of buff Korean people meet and do different like physical challenges to determine who has the best physique. And in Physical Asia, it wasn't just Koreans, it was people from a variety of Asian countries, including Australia. It is incredible TV. Each episode is an hour and 40 minutes. Korean TV will not compromise with your limited attention span. It's an hour and 40 minutes of people like lifting like ships, like boats. It's crazy. It's the furthest you can be from Resolution 2803.
Can I just say, I 100% agree that from a geopolitical frame point as well as a footballing frame point, Australia is an Asian nation and we need to stop denying that. And we should actually have our UN category moved out of European and others into Asia because, of course, we fucking should. We're an Asian nation.
Well, absolutely. But can I also just say, I love the idea that we can get off our devices and regain an attention span long enough to finish, finally, in my case, reading War and Peace, which I've started several times, by watching Korean reality television. Like I'm gonna go up from Instagram attention span to full like literary fiction attention span
I
via the medium of excessively buff people competing with
Can
each
I
other.
ask a question? Do they do it? Do they end up having any of like the crazy Mongolian horse archery as some of their physical challenges? Because that shit's awesome to watch.
So there isn't Mongolian archery, but there is a Mongolian team, and
Awesome.
their whole like little thing that they do when they enter the scene is to mimic the Mongolian horse archery. So
Awesome.
I
Love
cannot
that.
emphasize like enough how amazing it
Okay,
is.
sidebar. I'm so cool that I recently saw horseback archery where people shot rings at the Queanbeyan Medieval Fair. And
Quangers
outside
represent.
if you're outside Australia, Google Queanbeyan. You'll have to work out how to spell it first. Tamsin.
So I have been watching a very, very terrible animated comedy. I'm not even going to defend it in terms of quality, but it's fucking hilarious, and it's called Crapopolis. Um, which if you haven't seen it, I don't know what it's on overseas. In Australia, it's on binge. I know it's also been renewed for like two more seasons. They're in season three at the moment. It's renewed at least until the end of season five, and it follows this fictional family who are the tyrants of an ancient Greek region city. And deals with all of the mythology and nonsense that comes with that, which includes such wonderful lines early on of like, we're going to build an empire. And someone says, what's that? And he's like, I don't know, but it's going to be huge. And, and it is literally everything is deeply inappropriate. Think governance South Park in ancient Greece, and you're in the realm of what you're gonna get.
I think you
And
Ancient
presented it
Greek
really
gods didn't,
well.
yeah, ancient Greek gods did not respect like boundaries, gender categories, or very often consent. So I imagine there's a lot of ways that could go wrong.
there is, and they don't shy away from that, considering that one of the protagonists is a forgotten Greek god, and her husband, who is a hybrid between a centaur and a manticore.
Right, that's a tough interracial background to bring to primary school, I imagine. Um,
So there you go. I gotta sit there and say it's hilarious. It's unlike Korean reality buff TV. It's only like 20 minutes an episode, and it's an animated bit of nonsense and well worth your time and engagement. You'll laugh and it's funny. So yeah.
Fabulous.
And for our real final question, Douglas, tell us, what are you wearing today?
Well, I'm not wearing everything I've been wearing today now because it's a warm evening and it's now quite late and I've had more than one glass of semi-sorvy. But during the day, I was wearing uh, linen trousers made by my local seamstress with braces, a white shirt with broad blue pinstripes, and a blue floral bow tie that I sewed myself. My recent escape route having been sewing more of my own clothing, which has been a wonderful way to, one, make things. And I think it's good to make things with your hands when you do the kind of work we do. But two, to kind of re-engage with a beginner mindset, like actually learning things from scratch. But the other great thing about sewing is it's one of those really frustrating hobbies, like Tamsin, I understand, golf, where you spend a lot of time swearing because of problems you've made for yourself.
Yes, I will. I have become known to some people in the golfing space as GFC because get fucked
C word.
is something that I frequently say on the golf course to my golf ball.
There we are, and what an image to finish on, having discussed the fairly extraordinary President Donald J. Trump comprehensive peace plan. Um, Listeners, wherever you are, thank you for bearing with us. It's been quite a ride, and we have a number of more episodes to get out this season, but some very exciting plans for next year. So thank you for listening, and stay tuned. Bye bye.
Hi, everyone.
Bye.